Right. Belgium was not obliged to send him back. They could keep, they could process an asylum application on a number of criteria. If he has family there, it's at the discretion of the second or the third state to retain an asylum application and process it there. But basically here they did the easy thing. Let's send them back and we don't want to deal with this.
If detaining someone whilst an application for asylum is being processed is questionable in the eyes of the court, but as is sending them back to the country of the point of entry, what sort of, in the court's opinion, what is the best way to deal with asylum seekers whilst their application is being processed? Have they just called for the process being sped up, or?
Well, what do you think? The court doesn't have doesn't take any stance on this. Like it doesn't take a stance on what should be, or how should a violation be corrected in this case. What else? How can state authorities here redress this violation? The court doesn't. It's a court. It says whether there is a violation, why there may be a violation, but it doesn't. Remember, we talked about implementation. Implementation is up to national authorities to decide how they will redress this situation, any violation. Here, of course, in cases like this, it's not so simple what should be done. In Greece, I know that the way they are trying to respond to this, not only to the judgment, of course, obviously this is a bigger problem, a huge problem. It's not that whatever they do it just in response to this judgment. This was a very big blow to, of course, to Greece and to Belgium as well. But what the Greek government is trying to do, also in response to this, is to build detention centers, or where it can host, it can put asylum seekers for, I don't know, for a couple of months. Or camps, or whatever they will call them, so that they do not, they don't wander out in the street without any help. Because usually what happens, certainly in Greece, that each day about 600 of people enter Greece. This is huge for a country of 10 million people. And they're usually sent to the large urban centers because in smaller places they cannot really, live there. So they usually send them mainly in Athens, and either they're left homeless, or in order to survive they engage in some kind of illegal trade, petty trade, or just they get involved with different criminal rings that do all sorts of things in order to make a living, from begging to other kinds of activities. So it is a major social problem also for the city. So in this case, I think Italy at least partly has been doing this. Isn't it what they have done in Lampedusa, the center, the reception center, as they call them, where they put the asylum seekers until their asylum, at least some of them.
is there any country that asylum seekers are allowed to work for certain time during their arraignment process?
I don't know, but I don't think so. I don't know in Scandinavian countries, even though they have probably very few. They have, you cannot work there. So I doubt it. I doubt it that asylum seekers can work, are given the right to work while their application is being processed. So, just okay. So let's see if there's anything else. Okay, in this last case with a child, well, this was a case. This was also an important judgment because it extended Article 3 in another way, in a different way here. This was a case of a small child. Her mother was in Canada and had a permit, resident, was able to get residence permit, and as soon as she got residence permit, she asked a relative of hers who was in Belgium to collect her daughter from, I guess, yeah, it was Congo here, in order to bring her to Canada. So the child flew in, I think, in Brussels from the Republic of Congo with where she would stop for a few days where her uncle was, and then she would join her mother in Canada, who was waiting for her. So this girl was stopped in Brussels airport, and she was detained there for, I don't know, for weeks, for a couple of weeks actually.
Excuse me, sorry, and the child?
The child. So her uncle tried to take her out, but couldn't. So after a couple of weeks, that she was detained in a center near Brussels airport, she was then sent back. She was put on a plane and sent back to Congo, where supposedly an uncle of hers was waiting for her, but then no one was waiting for her there. Now, the court found a violation of Article 3, 8, and 5. This was multiple violations here. Article 3, why was Article 3 violated here? By Belgium. Okay, Belgium violated Article 3, 8, and 5 first of all, by detaining a 5-year-old child in centers that are not made for children, but they are for adults. Article 3, for considering this as inhuman treatment for a child, but also because the inhuman treatment was extended to her mother, who was extremely distressed to find out that her 6-year-old child was detained and then was sent back without being accompanied by someone back to Congo. So Article 3, the Strasbourg Court found a violation of Article 3, both because of the treatment of the child and because of the distress, indirectly the treatment of the mother because of the distress that she suffered. And Article 8, a violation of the right to family life, the right, the mother and the child to join, for the child to join her mother, who was her family. So the mother was also considered a victim under Article 3. Fortunately, the case was resolved after, I guess, the government of Canada, Belgium, and Congo intervened to resolve the case and to allow the girl to be flown to Canada. But the case is also indicative of the kind of extremes, the kind of extreme, not in terms of physical, in the sense of physical abuse, but the kind of harshness of treatment that may be meted out to some individuals. Yes. Well, think about these cases when we debate Hoffman's argument, whether we actually need the Strasbourg Court or not. He has a good point, but if you think of cases like this, I think then you wonder whether national authorities always get it right. Strasbourg doesn't always get it right, but what's the alternative? I mean, national courts do not always get it right either.
Sorry, what's Article 5?
Article 5 is liberty and security. So it has a number of points. Article 5. I don't think I have. We can look it up afterwards. I have the convention here, but you have it also. You have the text of the convention in the readings that were sent to you.
Why was that? Why was it violated? How was it violated?
Can you speak up?
How was it violated?
Article 5, because the girl was detained for weeks, so her liberty was violated.
It was 3 and 5.
The girl was 5, 6 years old. She was detained for weeks. I don't remember how many weeks, but for a while. So she was, it violated Article 5 because of her detention, and her detention without very good reason.
And the Article 5 is violated
because she was detained. Because she was detained, and because she was detained also in a place that is made for adults, in centers that are not intended for children. Okay, and one example from this, and then we can move on. A violation of family life. This is a typical case, the Umed versus the Netherlands. It's a characteristic of a much larger number of cases that the Strasbourg Court has reviewed, where you have immigrants who live in a country and who are expelled, who are facing expulsion. This was the case with this individual, Umer, who I think was from Turkey, and lived in the Netherlands since he was young, since he was 10 or 12. He had moved to the Netherlands and lived there for years. He was charged with manslaughter in the Netherlands at the age of 25 or something. The Dutch authorities issued an expulsion order against him, not permanent expulsion, but for 10 years. So they ordered him to leave the country and remain abroad, back to his country, presumably for 10 years, and then he would be allowed to return back. He argued in the Strasbourg court that his expulsion would violate his right to family life, because in the Netherlands he had, I don't remember if he was married or not, but he had a son. He had one child, and then subsequently, while the case was pending before the court, he had a second child as well with his partner or wife. I don't remember what it was, or who was a Dutch citizen. So the court here had to consider whether, okay, by sending him back to his country, because he committed a serious crime, he was charged for manslaughter.
What does it mean?
Killing someone. On the one hand, of course, he would be separated from his family, since he had a wife or a partner and 2 children who were young children and would have to grow up, for the next 10 years without the presence of their father. Here the court, the court did not find violation of Article 8. So basically it accepted, it justified the decision of the Dutch authorities to expel him for 10 years. The court didn't find a violation of Article 8 in this case. Why not? Usually the court considers these cases in a very contextual manner. It very much depends on the circumstances of each individual here. Here, of course, there are family ties, but also the court took into consideration the fact that he had lived with his partner and his children, but he was not permanently living with them. So that, of course, was not, it weakened the nature, the strength, of family ties, which were there, but the fact that he hadn't lived with them for years, that made his argument not as strong. So the fact that there was a criminal conviction, so it's not like it's a serious crime. It wasn't like theft or he had killed someone, so that's a serious crime. So how serious the crime is. I think these were the reasons that the court did not accept that there was a violation of Article 8. So this is a typical case of a much larger number of cases where you have expulsion versus, for some reason of the sort, versus family life, the right to family life. Now, you know, as you can already guess from what we said about the MSS case, when it comes to implementation, okay, we have the court issues the judgments here. But when it comes to implementation, what happens afterwards? What do national authorities do with these judgments? The question gets much more complicated. Usually, I mean, the judgments of the court have been influential in improving the rights of asylum seekers. They don't give the right to asylum. There is no right to asylum. There is no right to remain in another country as an immigrant. Even if you have a residence permit, we saw that if you commit a crime, you can be asked to leave the country. But the court's judgments have helped to improve how immigrants and asylum seekers are treated and that's not, again, clear because it has put some pressure on national authorities to improve, for instance, their asylum seeking, the asylum seeking process. In Greece, 10 years ago, asylum applications were being decided by administrators, by the police actually, where they would deposit an application and they would decide about whether a person should be granted asylum or not. Now, this is no longer the case. After the Strasbourg court found this to be contrary to the right to a fair trial, right? Because police, public order officers are not competent to decide. They should not be competent to decide on asylum issues. Judges should decide on asylum issues. So there is pressure, to improve the conditions of detention. Not that conditions of detention are good now. I don't know if they're better than they used to be, but there's the pressure. The judgments of the court do introduce pressure, that they also set standards, even if they're not followed necessarily, but it is important that they are there they give justice, they give legitimacy to the claims of these individuals. Now, one thing that the court can do in the short term is to issue so-called the interim measures. Let's say a government issues an expulsion order against an individual who is claiming protection under Article 3 on grounds of non-refoulement, claiming that it was sent back to the country they're likely to be faced with ill treatment. What happens until the court makes its decision? That can take, now actually it can take years in the Strasbourg court. What the court does with interim measures is to issue, at the request of the party, to issue interim measures asking national authorities not to implement an expulsion order until a final decision is made on whether Article 3 AGA is involved or not here. The court has actually received many such requests for interim measures. This is the Rule 39 of the court rules that enable the court to issue interim measures. Under Rule 39, such requests have risen by 4,000%. I guess the number must be extraordinary. In 2006 there were 112 such requests, and in 2010 there were nearly 5,000 such requests. So you can imagine how important this is. And you can see some data about countries here.
Why so many cases against UK?
These are requests for interim measures. Why so many requests against the UK? I'm not sure. One answer may be that these usually are about expulsion. One thing I could guess, can you guess why so many against the UK?
When is it since?
Just in 2010.
Changing government?
Well, it's probably not going to change the government. First of all, the UK has, you have to think also of the population. There are just some basic, that you can think, it probably has to do also with the fact that the UK is a big country and it has large numbers of immigrants. A larger number, of immigrants.
But also France is a big country and has only 300.
It's true. So another thing that one could think then is perhaps if it has to do with all the anti-terrorist legislation that has been introduced in the UK, and which leads to has increased the number of expulsions. So it may very well be linked to the anti-terrorist measures and the anti-terrorist legislation that has been introduced in the UK, and perhaps that's why you have many more in the UK and fewer in France. And I don't know how many foreigners or immigrants live in Japan, but approximately they shouldn't vary very much in terms of the absolute numbers of. So it may very well have to do with this. And of course, these are a huge burden on the court, which is already hugely burdened by an extraordinarily high backlog, which we will see later on. Okay, we've already seen this. And just okay, when it comes to immigration, we're not going to go through this because we don't have good times. So as far as the domestic impact of immigration-related rights, generally, I I mentioned also yesterday that one impact, one positive impact is with regard to access to social benefits. I think that has been a positive impact that can clearly be linked to the Strasbourg Court judgments. That it has influenced countries like Austria to get rid of discriminatory provisions that excluded foreigners from using social services like emergency assistance. But these are a few cases. When it comes to the much larger numbers of cases that we've just looked at about asylum seeking, detention, anti-terrorism, it's very implementation is very is extremely difficult. There's generally reluctance of national authorities to undertake reforms, to reform their immigration policies, and to give up any sovereignty or any their ability to decide who comes in the country and who has to leave the country. Okay, I think we can stop here. These are about minorities, and I don't think there's any need to go back to the minorities. We've already discussed this yesterday. Okay, any questions so far? Okay, let's end this second part of the class then.
So can you just go back to, is it possible to go back to the
Yes,
which was previous to this one?
This one?
Yeah.